Welcome to Goal Outlet, your guide to entrepreneurship and digital marketing with your host, Mike McDermott. Goal Outlet dishes up killer growth hacking strategies from today's small business movers and shakers. Find out more at goaloutlet.com. Thanks for listening.
Good morning and welcome to Goal Outlet, where setting your goals and realizing them. I am your host, Mike McDermott, and we are talking today about GDPR. That's right. And the title of this podcast today is GDPR Compliance, a 20-minute review of the largest privacy and compliance law in more than 20 years. Okay, so in the next 20 minutes, I'm going to try and deliver enough information for the small business owner to understand and then take action regarding this particular privacy and compliance law. So here we go. What is GDPR? The General Data Protection Regulation, or GDPR, is a European Union regulation which serves to protect the personal data of anyone in the EU. So if you are an EU citizen, or simply live, work, or travel through the EU, then you and your personal data are considered in scope. Okay, so that's pretty big, right? So what's that saying there is that if you're a citizen, or if you're traveling, or if you're vacationing in the EU, your personal data while you are there is in scope. Okay, so that's very, very, very important. The term regulation, as they have it here in the EU, means that once the GDPR was published back in May of 2016, it instantly became the law in all 28 EU member states. Now, you may recognize that this differs from an EU directive, which each country interprets into its own law. So an EU directive, it would be like, you should protect people's data. And then Italy would be able to define how they do that, and the UK is able to identify how you do that, and Germany is able to define how you do that. Now, as a regulation, none of those member states, all 28 EU member states, soon to become 27 because of Brexit, have to follow this regulation. Regulations are implemented in the EU verbatim, and it ensures a level of consistency across all of the EU member states. So it was passed last year. When does it become into effect? May 25th, 2018. That's right. The GDPR will be enforced and must be complied with on May 25th, 2018. So if you haven't already prepared, it's probably good that you're listening to this podcast. Well, you ask Mike, say, hey, Mike, why are you even talking to us about an EU regulation? We live in the United States, you know? Heck yeah, America. Well, if you sell products or services to people, businesses, or government entities in any one of the 28 EU countries, if you send an email or collect data from in the way of a web form, a chat dialogue, or on social media, or if you sell products to people, businesses, or government entities in the EU, this affects you. This also affects you if you send an email or collect data from in a form, chat, dialogue screen, or social media, or sell products to or services to a person who has dual citizenship. So someone could be a citizen of Italy residing in the United States, paying U.S. taxes, working right alongside you. They have dual citizenship. They are protected by this. If you have them on your email list, this is in scope, right? So all of the new regulations for the GDPR applies to this person, those protections, okay? And if you perform any of the aforementioned activities on a U.S. citizen who travels for work or leisure and declares temporary or permanent domicile, okay? So that could be anybody. Say, hey, I just traveled to the south of France, spent a week on a yacht, and I decided I want to stay here, right? So this is a person that you used to have on your marketing list. You're marketing them furtively, and they decided to kind of go off the radar and declare temporary residency in France or Spain or Portugal or Germany or Italy. And now that person's privacy is in scope. So you say, Mike, I have a small business. I don't think this applies to me. Well, if you answered no to all of those other things, say my email list is small, I don't internet market, I really don't think that this is going to apply to me. Well, just wait. California is placing a ballot measure out there in November of this year called the California Consumer Privacy Act of 2018. If passed, the act is going to work similarly to that of the GDPR. The measure in California is intended to give Californians more information and control over how their data is being used. And it's going to apply to all businesses that use consumer data for commercial purposes, not just technology or internet companies. Okay, so there's been limited scope legislation passed in several states regarding restrictions on technology and internet companies. Like Google is not allowed to do this, or Facebook is not allowed to do this. So there's been legislation like that that's been bandied around. And, it seems to have some sort of focus right now. California has basically looked at the GDPR and said, hey, we would love to have all of that for our residents. And they are going to put that on the ballot. Now, personally, so this is inner Mike talking. I don't think the California law is going to pass. At least the first time it won't. Unless it is written very convincingly, right? So ballot language is incredibly important here. If ordinary Tom, Dick, and Harry walk into a California voting booth, hopefully an individual voting booth, Tom gets one, Dick gets one, and Harry gets one. They go into the voting booth and they decide to read the ballot language, and it says this legislation, this ballot initiative is to provide better protections on everyone's personal data that lives in California. Tom, Dick, and Harry may decide to go in and say yes to that. So what that would mean would be that if you sell anything or have anyone that lives in California on your list, you have to take them off that list if they request so. We'll get a little bit into that here in the second half. The real kicker on the California legislation, right? And so, of course, how many attorneys live in California? Plenty. Okay, so it allows public prosecutors and citizens to sue for data breaches or for the sale of personal data after someone has opted out. So you tell a company, take me out of your database in California after this legislation passes. There's no requirement that specific harm be proven before damages can be awarded. So you literally can make the claim, you took my data, you did not destroy it as I asked you to destroy it, and you continued to market to me, and you owe me $200,000 in damages. That's legitimate within the scope of the legislation in California right now. That's up in November. So If you live in California and you listen to this show, consider your options. Okay, so I talked a lot about the what GDPR is, when it's going to be enacted on the 25th of May, and what is it exactly? What exactly are the terms? What are the privacies that we gain, that the EU residents gain from GDPR? Well, they gain the right to be forgotten. Okay, so Article 17 of GDPR states that the data subjects have the right to have their personal data removed from the systems of controllers. So those are the people that you gave the data to, and processors under a number of circumstances, such as that by removing their consent for its processing. Okay, so say you gave your data to Procter & Gamble because you wanted a coupon, right? Procter & Gamble gave your data, your email address and your contact information to their mail house to mail you stuff. They also gave it to their email marketing company, and so they're emailing you. And they also gave it to the social media company that is that is putting ads out there and showing them to you. So when you in the EU contact Procter & Gamble, you can say, I would like all of my information deleted. So Procter & Gamble has to delete it. Then they have to request that the processor, the email company, the mail house, the social media company, they all have to delete it as well. So it's akin to requesting your neighbor return the leaf blower that you lent them, right? So you lent them a leaf blower. You say, hey, neighbor, can I have my leaf blower back, right? It's yours. You want it back. Previously, data processors such as cloud hosting providers, email delivery companies, digital marketing companies were not in scope for data protection requirements. Instead, all the responsibility for the failure of a data breach or the failure of following privacy laws came down to the data controller. GDPR changes all of that, and now processors share the burden of data protection with the controller. Okay, so the data subjects, right? So a data subject would be a resident, a citizen of the EU. They have the right to obtain the erasure of the data. Say the company doesn't need the data anymore. The controller and or the processor is processing the data unlawfully. There is a legal requirement for the data to be erased. The data subject was a child at the time of collection. In Article 8 of the GDPR, it fully defines how children may end up opting into marketing, and then also how that data about children is handled. Most specifically, you can, at the age of 18, according to GDPR, right? At the age of 18, a minor, now a major, right? Once they turn 18, you can request that all data be removed from your profile, fully deleted, right to be forgotten, right? So say you started a Facebook page you had when you were 15, and between 15 and 18, you posted a bunch of dumb crap on Twitter, a bunch of dumb crap on Facebook. When you turn 18, GDPR, you can go in and request Facebook, go delete all my pictures, go delete all of my posts. I don't want anyone to see them. Delete that and in the cache archives. Right now, people still could have, screenshotted that crazy picture of you or embarrassing one. That still could have happened. But that data control has to get rid of it. That data processor has to get rid of it. All right. Highlights of data portability. Okay, so what happens if you just don't want your data deleted? You want to move it, right? Article 20 of GDPR ensures that if you have data on a person, that they have the full and complete access to that data. So data portability requires that a data processor or a data controller release the customer data in a machine-readable format, so CSV or XML, to the data owner or the third party that the data owner designates. This means that a data owner can take all of your historic investment data from your system over at Ameritrade and send it over to Charles Schwab, right? Previously, you couldn't do that. You could, if you called Ameritrade and said, "Hey, I want all of my historic data, of all of the trades and all that stuff that I did with you when I was your client," Ameritrade could go say, "No, go take a jump in a lake. That's our data. That's in our system. It's kind of like the stuff that we do. It's kind of proprietary to us. We kind of like to hold on to that. Thank you very much." And we're definitely not going to send it to Charles Schwab. So financial data, you actually get it. You get all of your data when you ask for it under GDPR. And the right of the data owner to obtain their data may not infringe on the rights of others that their data touches or interacts with. Okay, so say you and say you have a partnership and you go into business and you have some data that is being stored by a data processor and a data controller, and then you say, "I would like all of my data." And if all of your data also has to deal with the rest of the partnership, right? So the finances of the partnership, you can't go in and request that because it's commingled data, okay? So only personal data is in the scope of the portability request. Any data that is anonymized or doesn't concern the subject will not be in scope. Pseudo-nominized data is in scope. Okay, so that means if they take your first name off but they leave your last name, or they take your last name off and leave your first name. The right applies to data provided by the data subject as opposed to inferred data or derived data. Okay, so what that means is if you go to a website and you provide your first name, last name, email address, phone number, and the color of your hair. Okay, you provide all that information to the data controller. The data, and then you come and say, "Hey, I want you to get rid of that data. I want you to get rid of that data," or even better, data portability, right? Because we're talking Article 20. I want my data back, right? They only have a responsibility to give you back your name, first name, last name, address, or email address, phone number, and the color of your hair. Now, they may have done something with that data after you gave it to them. They may have added mailing address. They may have done any number of data aggregation activities on the data that you provided to them. They may have added sales habits. They may have added geolocation information, right? But what you're doing is you're asking that your personal data that you provided to them get returned back to you, and they don't have to give you all of the other sideline data, basically, that they created on you. But what they have done is separated that from the owner, right? So that information is pretty much useless to them. All right? The data subject even has greater rights than before with direct control over the usage, retention, and movement of their personal data. This includes the right to erasure, which is what we called the right to be forgotten, or the right to portability. Okay, so rights to consent are now much tighter within the EU, with controllers generally needing to provide greater detail of what processing is to be performed, along with unambiguous opt-in style consent. Okay, so in the GDPR, the information about privacy cannot be stuffed into your terms of service document that's 11 pages. You have to make the process for understanding privacy and the process for acquiring data on your site very transparent. Okay. All right. So now we're getting to the end of this 20 minutes here really quickly. But the highlights of the GDPR that is most interesting for those that our data controllers or data processors are the fines and penalties. If you fail to comply with the GDPR, then the cost can be huge. The maximum administrative fine that a regulator can impose is 20 million euros, which today is $23.6 million in the United States, or 4% of the annual revenue of the parent company. So that could be a lot of money. Contrast this to the UK's current maximum fine of £500,000 under the Data Protection Act. And you can see that the GDPR comes with a very big enforcement stick. These fines are purposefully high in order to be effective, proportionate, and dissuasive. Additionally, data subjects themselves and collective groups have the right to take controllers to court and sue for damages. In many large breaches, a class action lawsuit would be more costly to the controller than any administrative fine from the regulator. So these regulators want you to follow their rules in the EU. And in fact, they've even said the controlling authority for the GDPR has said that they will, quote, make examples of, close quote, the first dozen or so companies that are found in non-compliance. So that's always good, right? You want to be made an example of. Okay, so breach notification. If a data controller has a breach of personal data, depending on a severity of it, they have 72 hours from the point of detection in which to notify the regulator and potentially the affected data subject. This is a major shift from many EU organizations who have no such requirements currently. Oh my gosh, could you even imagine this, right? Today, I mean, what do we hear in the news? We hear in the news here in the States that, Target lost, had 12 million credit cards and personal information stolen 6 years ago. And they're just getting around to tell us, right? That's not cool. That's not cool, right? But so what does this do, man? This is like the snapback. This is like the snapback of a rubber band, right? Where it got really crazy, and now it's getting the other way. 72 hours. That's pretty quick. That's really quick. Okay. Previously, data processors, right? So these are the cloud hosting organizations and stuff like that. Email delivery companies. That's your constant contact, right? Your SharpSpring, and your marketing agency, right? They were not in scope, right? Instead, all of the responsibility fell on the controller of the data. So we have to keep track of your data just as well, right? So your data, your digital marketing company has to keep as good track of the data as the controller should. So that's a big change. All right. So what happens if you have a large amount of data, special categories of data, you're a government entity, or you need to designate, or you are you deal with sensitive data, right? You need to designate a named data protection officer. Okay. So it's not a unmanned position. This person is the organization's data protection lead and the principal advisor in all data protection activities. This person cannot be your CTO, cannot be your CIO, they cannot be your director of security, they cannot be your CISO, they cannot serve in any role in sales or marketing with the organization due to conflict of interest. This person's role will be to advise the data processor or controller during the development of projects that deals with data compliance and will not be a doer who's also responsible for the actual data protections involved, right? So this is an outside entity. That's the way it reads to me is like, you're not going to assign this to customer service. You're not going to assign this you can't assign it to marketing or sales. If you have an attorney that you have on retainer or in-house attorney, that person could do it. The data protection officer or DPO can be a third party or a third party entity who's experienced and knowledgeable in GDPR, security, and compliance. Okay, so short stick if you have sensitive data and you're really concerned about it and you don't want to be fined, and you participate in activities where privacy data is rich, right? So I mentioned law firms, right? So if you're a law firm and you have people's financial data, you have all of their history data, you have all of their hidden secrets and stuff, right? Back and forth. How's that getting logged? Names, addresses of people, when people were contacted. You have a lot of data, and the chances of that data, becoming breached, could be high, and the data could be valuable. Right. That's the other thing, is if there's financial data involved, it could be valuable. You should get a data protection officer assigned. Has to be a named person. You have to be able to call them on the phone. You have to be able to email them. And the requests for removal, right? The ability to be forgotten, right? As well as the ability to download data. That person has to be in charge of that. Not the activity, but they have to have oversight. Okay, so what's next? Okay, so if you're listening to this podcast and you are a Bashfu client, where we do marketing for you, if Bashfu currently serves your company in any marketing or sales capacity, we cannot also serve as your data protection officer due to the conflict of interest. We can provide timely updates on GDPR, just like this, as well as make sure that your systems are working to become more GDPR compliant. We can create a project to ensure proper compliance with GDPR, as well as support the new technical data erasure, storage, and transmission requirements as spelled out by this regulation. If you are not currently our client, and you believe that your organization does deal with a large amount of sensitive consumer data, or that you feel that the transmission, storage, and retention of that data does not comply with the new GDPR regulations, Bashfu can serve as your named data protection officer. Even if you do believe that you're in compliance with GDPR regulations, if you have not assigned a data protection officer and you experience a data breach in the future that affects EU clients, affects residents of the EU, you will be responsible to answer to the central authority. I know that's crazy, right? So central authority, like 1984, right? They actually call it central authority. So I'm not making that up. You'll be responsible to answer to the central authority on the reasons why you did not care to assign this important role in the protection of consumer data, and you will be responsible for remediation and possibly fines and administrative fees due to all of that. So I think I ran over 20 minutes. I tried not to. GDPR is an important subject. It does affect you if you're an American company. It especially affects you if you deal with sensitive data and if you have mailing lists. So having a mailing list is not a bad idea. It's actually a really good idea to go in and market your company using email. However, there's certain things you need to do. So if you have any further questions, you know how to get a hold of me, and you know how to get a hold of your attorney to ask them more questions about this very important issue. Hope this podcast has been helpful for you. This is Mike McDermott with Goal Outlet, setting goals and realizing them. Have yourself a great day.